Q. The legal yardstick in determining whether usage has become customary international law is expressed in the maxim opinio juris sive necessitates, or opinio juris for short. What does the maxim mean? The maxim opinio juris sive necessitates, or simply opinio juris, means that states observe a practice or a norm out of a sense of legal obligation or a belief in its juridical necessity. Opinio juris is the subjective element of international customs, the objective element being the long and consistent practice of states. Q. Under international law, differentiate hard law from soft law. Hard law refers to binding international legal norms or those which have coercive character. Soft law, on the other hand, refers to norms that are non-binding in character but still have legal relevance. Examples of hard law are the provisions of the UN Charter, the Vienna Convention on Diplomatic Relations, the Geneva Convention of 1949, and other treaties in force. Examples of soft law are resolutions of the UN General Assembly and draft articles of the International Law Commission. Soft law usually serves as a precursor of hard law. The Universal Declaration of Human Rights is one such example. It was a soft law when it was adopted by resolution of the UN General Assembly in 1948, but it has led to the development of hard law with the adoption of two binding covenants on human rights. Example, the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights. Q. May a treaty violate international law? If your answer is in the affirmative, explain when such may happen. If your answer is in the negative, explain. Yes, a treaty may violate international law when at the time of its conclusion it conflicts with the preemptory norm of general international law, jus cogens, or if its conclusion has been procured by the threat or use of force in violation of the principles of international law embodied in the Charter of the United Nations, Vienna Convention on the Law of Treaties, Articles 52 and 53. Q. The President alone, without the concurrence of the Senate, abrogated a treaty. Assume that the other country party to the treaty is agreeable to the abrogation provided it complies with the Philippine Constitution. If a case involving the validity of the treaty abrogation is brought to the Supreme Court, how should it be resolved? The Supreme Court should sustain the validity of the treaty abrogation, while the Constitution is expressed as to the manner in which the Senate shall participate in the ratification of a treaty. It is silent as to the body's participation in the abrogation of a treaty. In light of the absence of any constitutional provision governing the termination of a treaty, and the fact that different termination procedures may be appropriate for different treaties, the case must surely be controlled by political standards, even more so because it involves the conduct of foreign relations. Q. William, a private American citizen, a university graduate and frequent visitor to the Philippines, was inside the U.S. Embassy when he got into a heated argument with a private Filipino citizen. Then, in front of many shocked witnesses, he killed the person he was arguing with. The police came and brought him to the nearest police station. Upon reaching the station, the police investigator, in halting English, informed William of his Miranda rights and assigned him an independent local counsel. William refused the service of the lawyer and insisted that he be assisted by a Filipino lawyer currently based in the U.S. The request was denied, and the counsel assigned by the police stayed for the duration of the investigation. William protested his arrest. A. He argued that since the incident took place inside the U.S. Embassy, Philippine courts have no jurisdiction because U.S. Embassy grounds are not part of Philippine territory. Thus, technically, no crime under Philippine law was committed. Is William correct? Explain. No. William is not correct. While Article 22 of the Vienna Convention on Diplomatic Relations provides that the premises of a diplomatic mission shall be inviolable and may not be entered by the police or by any other agent of the receiving state, except with the consent of the ambassador or the head of the mission. It does not alter the fact, however, that such premises are still part of Philippine territory. The concept of exterritoriality, under which diplomatic premises are deemed to be part of the sovereign territory of the sending state, has not yet been adopted in the Vienna Convention. Hence, a crime committed on or within such premises by a private person like William, who enjoys no diplomatic immunity, falls within the jurisdiction of Philippine courts. Q. A terrorist group called the Emerald Brigade is based in the state of Asia-land. The government of Asia-land does not support the terrorist group, but being a poor country, is powerless to stop it. The Emerald Brigade launched an attack on the Philippines, firing 2 missiles that killed thousands of Filipinos. It then warned that more attacks were forthcoming. Through diplomatic channels, the Philippines demanded that Asia-land stop the Emerald Brigade, otherwise it will do whatever is necessary to defend itself. Receiving reliable intelligence reports of another imminent attack by the Emerald Brigade, and it appearing that Asia-land was incapable of preventing the assault, the Philippines sent a crack commando team to Asia-land. The team stayed only for a few hours in Asia-land, succeeded in killing the leaders and most of the members of the Emerald Brigade, then immediately returned to the Philippines. Was the Philippine action justified under the international law principle of self-defense? Explain your answer. Yes, the Philippines' action was justified. Article 51 of the UN Charter affirms the inherent right of state to individual or collective self-defense. The terrorist group Emerald Brigade had already launched actual armed attacks on the Philippines, which killed thousands of Filipinos, with a warning that more attacks were forthcoming. Asia-land, on the other hand, had failed to fulfill its obligation under international law to prevent the use of its territory for the staging of terrorist acts against the Philippines. As such, in the face of another imminent attack by the Emerald Brigade, and it appearing that Asia-land was incapable of preventing the assault, the Philippines was therefore justified in resorting to military action to protect its own security as an act of self-defense. Q. As a consequence of the foregoing incident, Asia-land charges the Philippines with violations of Article 2.4 of the United Nations Charter that prohibits the threat or use of force against the territorial integrity or political independence of any state. The Philippines counters that its commando team neither took any territory nor interfered in the political processes of Asia-land, which contention is correct. The contention of the Philippines is the correct one. State practice and the UN Security Council's action after 9/11 indicate a trend towards recognizing that a state that suffers large-scale violence perpetrated by non-state actors located in another state has the right to use force when 1. That other state proves unwilling or unable to reduce or eliminate the source of the violence. 2. The use of force is proportional to the threat posed by the non-state actor. And 3. The use of force is temporary and does not result in non-consensual occupation or annexation of territory. Under UN/A/Res 60-288/2006, known as the UN Global Counterterrorism Strategy, member states shall adopt a plan of action including a number of measures to prevent and combat terrorism, in particular by denying terrorists access to the means to carry out their attacks, to their targets, and to the desired impact of their attacks. Assume that the commando team captured a member of the Emerald Brigade and brought him back to the Philippines. The Philippine government insists that a special international tribunal should try the terrorist. On the other hand, the terrorist argues that terrorism is not an international crime and therefore the municipal laws of the Philippines, which recognizes access of the accused to constitutional rights, should apply. decide. Terrorism is an international crime, both in times of peace and in times of armed conflicts, and therefore, it may be tried by a special international tribunal. The municipal laws of the Philippines cannot apply because the terrorist acts in question are transnational in nature, that is, not limited to the territory of the Philippines, and they do not fall under the extraterritorial criminal jurisdiction of the Philippines under Article 2 of the Revised Penal Code. When committed during peacetime, international terrorism may be prosecuted under the different international conventions on the prevention, suppression, and punishment of terrorism, and when committed during an armed conflict, it may be prosecuted as a distinct category of war crimes. International law indisputably bans terrorism in times of armed conflict. Article 33, Number 1 of the Fourth Geneva Convention of 1949 prohibits all measures of terrorism against civilians. A similar provision is contained in the Second Additional Protocol of 1977. Article 4, Number 2, letter D, prohibits acts of terrorism against all persons who do not take a direct part or have ceased to take part in hostilities. Q. The Philippine government is negotiating a new security treaty with the United States, which could involve engagement in joint military operations of the two countries' armed forces. A loose organization of Filipinos, the Kabataan of Matatandang Makabansa, KMM, wrote the Department of Foreign Affairs, DFA, and the Department of National Defense, DND, demanding disclosure of the details of the negotiations, as well as copies of the minutes of the meeting. The DFA and the NDA refused, contending that premature disclosure of the offers and counter-offers between the parties could jeopardize ongoing negotiations with other countries. KMM filed suit to compel disclosure of the negotiation details and be granted access to the records of the meetings, invoking the constitutional right of the people to information on matters of public concern. Decide with reason. The suit filed by KMM should be dismissed. It is true that the details of the treaty negotiation, including the offers and counter-offers between the Philippine government and United States, are matters of public concern. However, it is also well established in jurisprudence that neither the right to information nor the policy of full public disclosure is absolute, there being matters which, albeit of public concern or public interest, are recognized as privileged in nature. As held in the recent case of Akbayan v. Aquino, GR 170516, the privileged character of diplomatic negotiations has been recognized in this jurisdiction. In discussing valid limitations on the right to information, the Supreme Court in Chavez v. PCGG held that information on intergovernment exchanges prior to the conclusion of treaties and executive agreements may be subject to reasonable safeguards for the sake of national interest. Even earlier, the same privilege was upheld in People's Movement for Press Freedom versus Manglapus, wherein the Supreme Court stressed that secrecy of negotiations with foreign countries is not violative of the constitutional provisions of freedom of speech or of the press, nor of the freedom of access to information. Will your answer be the same if the information sought by KMM pertains to contracts entered into by the government in its proprietary or commercial capacity? Why or why not? No, the answer will be different. Information pertaining to contracts entered into by the government in its proprietary or commercial capacity are not covered by the doctrine of executive privilege. These information are matters of public concern to which the people have the right to information under Section 7 of the Bill of Rights. Under Section 7, citizens shall be afforded access to official records and to documents and papers pertaining to government transactions. Moreover, Section 28 of the Declaration of Principles directs the state to adopt and implement a policy of full public disclosure of all its transactions involving public interest. 2010. Q. The dictatorial regime of President A of the Republic of Gordon was toppled by a combined force led by General Abe, former Royal Guards, and the secessionist Gordon People's Army. The new government constituted a Truth and Reconciliation Commission to look into the serious crimes committed under President A's regime. After the hearings, the commission recommended that an amnesty law be passed to cover even those involved in mass killing of members of indigenous groups who opposed President A. International human rights groups argued that the proposed amnesty law is contrary to international law. Decide with reason. The proposed amnesty law is contrary to international law. The indigenous group may constitute an ethnic group which is protected by the law on genocide. If the mass killing was committed with the intent to destroy those specialists, the said ethnic group as such, in whole or in part, then the crime of genocide was committed. The international norm for the prevention, prosecution, and punishment of genocide is a peremptory jus cogens norm of international law and therefore non-derogable. Prosecutor versus Blagojevic and Jukic, January 17, 2005. Even if the mass killing was not committed with the dolus specialists to destroy the ethnic group as such, the same may still constitute the crime against humanity of extermination if the mass killing was widespread and systematic, or the war crime of internationally attacking civilians if the same took place in the context of or was associated with an armed conflict. The norm for the prevention, prosecution, and punishment of crimes against humanity and war crimes are also customary norms of international and therefore binding on all states. Thus, Republic of Gordon has the obligation under international law to prosecute and punish all those involved in the mass killing of the members of the indigenous group, and providing amnesty to those involved is violative of this obligation. Compare and contrast the jurisdiction of the International Criminal Court and International Court of Justice. The jurisdiction of the International Criminal Court, ICC, primarily deals with the prosecution of individuals for core international crimes, while the jurisdiction of the International Court of Justice, ICJ, deals with contentious proceedings between states. As to subject matter jurisdiction, ration materiae, the jurisdiction of the ICC is limited to the most serious crimes of concern to the international community as a whole, particularly A, the crime of genocide, B, crimes against humanity, C, war crimes, and D, crime of aggression. On the other hand, the jurisdiction of the ICJ covers legal dispute which the state refers to it. This includes disputes concerning A, the interpretation of a treaty, B, and a question of international law, C, the existence of any fact which, if established, would constitute a breach of an international obligation, and D, the nature or extent of the reparation to be made for the breach of an international obligation. The ICJ also has jurisdiction to give an advisory opinion on any legal question as may be requested by the General Assembly or the Security Council, or on legal questions arising within the scope of the activities of other organs and specialized agencies of the UN, upon their request and when so authorized by the General Assembly. As to jurisdiction over the persons or parties, the ICC shall have the power to exercise its jurisdiction over persons for the most serious crimes of international concern, and shall be complementary to national criminal jurisdictions. Article 1, Rome Statute. On the other hand, only states may be parties in cases before the ICJ, and their consent is needed for the ICJ to acquire jurisdiction. Q. A photojournalist was covering the violent protests of the Thai red shirt movement in Bangkok. Despite warnings given by the Thai Prime Minister to foreigners, especially journalists, A moved around the Thai capital. In the course of his coverage, he was killed with a stray bullet, which was later identified as having come from the ranks of the red shirts. The wife of A sought relief from Thai authorities but was refused assistance. Is there state responsibility on the part of Thailand? B. What is the appropriate remedy available to the victim's family under international law? A. No, there is no state responsibility on the part of Thailand because the acts of the Thai red shirt were not the acts of Thailand. Under the principle of attribution or imputation, a state only incurs liability for individual acts or omission which can be attributed to it. The Thai red shirts are not its official agents or representatives, and they were not acting on the instruction of or under the direction or control of the Thai government. R. Sarmiento, Public International Law Bar Review 2009, Revised Edition 65 to 66. Letter B. Unless the red shirts become the new government of Thailand or Thailand acknowledges and adopts the conduct of the red shirts as its own, the victim's family has no appropriate remedy under international law. The remedy, if any, if only available under the domestic laws of Thailand, by the institution of the appropriate criminal cases against the persons responsible for A's killing and the filing of an action to recover damages arising from A's death. Q. Choose the statement which appropriately completes the opening phrase. A state which resorts to extortion in international law. A. Must ensure that all states consent to its act. B. Cannot curtail migration from the offending state. C. Can expel the nationals of the offending state. D. Should apply proportionate response within a appreciable time or limit. E. None of the above. Explain. Suggested answer, letter D. A state which resorts to extortion in international law should apply proportionate response within appreciable limits. Retortion consists in retaliation where the acts complained of do not constitute a legal ground of offense, but are rather in the nature of unfriendly acts done primarily in pursuance of legitimate state interests, but indirectly hurtful to other states. To be valid in international law, acts of retortion should not be excessive when compared to the unfriendly acts committed by the offending state. Moreover, they should not violate a state's obligation under Article 2, Number 3 of the UN Charter to settle their dispute by peaceful means in such a manner that international peace and security and justice are not engendered. Q. Which statement best complete the following phrase? Freedom from torture is a right. Letter A. Subject to derogation when national security is threatened. B. Confined only during custodial investigation. C. Which is non-derogable both during peacetime and in situation of armed conflict. D. Both A and B. E. None of the above. Answer. Letter C. Freedom from torture is a right which is non-derogable both during peacetime and in a situation of armed conflict. Article 2, Number 2 of the UN Convention Against Torture provides that no exceptional circumstances whatsoever, whether a state of war or a threat of war, internal political instability, or any other public emergency, may be invoked as a justification of torture. Because of the importance of the values it protects, the prohibition of torture has evolved into a peremptory norm of or jus cogens, that is, a norm that enjoys a higher rank in the international hierarchy than treaty law and even ordinary customary rules. The most conspicuous consequence of this higher rank is that the norm prohibiting torture can be derogated from state through international treaties or local or special customs or even general customary rules, not endowed with the same normative force. Q. What is the concept of association under international law? Under international law, an association is formed when two states of an equal power voluntarily establish durable links. In the basic model, one state, the associate, delegates certain responsibilities of the other, the principal, while maintaining its international status as a state. Free associations represent a middle ground between integration and independence. In international practice, the associated state arrangement has usually been used as a transitional device of former colonies on their way to full independence. Examples of states that have passed through the state of associated states as a transitional phrase are Antigua, St. Kitts, Nevis, Anguilla, Dominica, Santa Lucia, St. Vincent, and Grenada. All have since become independent states. In deciding the constitutionality of the Memorandum of Agreement on the Ancestral Domain, MOA-80 aspect of the GRP MILF Tripoli Agreement on Peace of 2001, the Supreme Court had ruled that the concept of association under international law is not recognized under the 1987 Constitution, as it runs counter to the national sovereignty and territorial integrity of the Republic. Province of North Cotabato versus GRP Peace Panel on Ancestral Domain.